first case to come before us is State versus Wilson. And both sides will have 15 minutes. You both have been here many times, so I'm sure you understand the rules. But I'll just remind you a little bit that please stand behind the podium there. Keep your voice up because we are going to be recorded, and the appellant may have up to 5 minutes for rebuttal. If you so choose, just let me know. And you each get 15 minutes, and we do have our monitor over there that helps us out with the time. So, are you ready to begin?
Thank you, Ronald. Good morning, and may it please the court, I'm Jacqueline at Cordo on behalf of the state, which unusually is the appellant in this appeal. And
I had to look at you twice.
and I would like to reserve 3 minutes of my time for rebuttal, if I may.
Thank you.
Your Honors, again, this is the state's appeal, an unusual appeal of the trial court's decision to suppress the defendant's confessions to a Springfield Township police officer. And thus, it is the sole question before this court is did the trial court reach an incorrect conclusion of law when it suppressed the defendant's statements? And the state's position is that it did for a couple of, well, actually for one main reason. Because there really is a two-step analysis that the trial court is required under U.S. Supreme Court precedent and Ohio Supreme Court precedent to follow in determining whether a person's statement to police was voluntary. The first step is to determine whether there was a coercive tactic employed by the police officers during the course of the questioning. Unless there was a coercive tactic employed, the court is not to move on to the second part of the test, and that is to determine whether, under the totality of the circumstances, the statement was nevertheless voluntary, even in the face of the coercive tactic. The error that the trial court made in this case was that it went directly to the totality of the circumstances test and did not even examine whether there was an inherently coercive tactic employed by the Springfield police officer in this case. And it is this.
Could an argument be made, excuse me, that even though the court didn't lay it out in the manner that you're speaking of, that it basically, implicitly, I should say, said the same thing, because obviously it saw that there were certain things that were done by this police officer that were coercive?
I would argue no, Your Honor, because, under the Colorado versus Connolly decision, which was followed by State versus OC, that determination of whether there's an inherently coercive tactic has to be made first. And since this court has to undergo de novo review of that, the court should have made that explicit, that there was an inherently coercive tactic. Furthermore, under the lines of cases that have followed Colorado v. Connolly and the OC case, the tactic that was used by the Springfield police officer in this case could not be said to be inherently coercive. Examples of coercive tactics, for instance, those are things that are so extreme that an ordinary person would lose the will to resist the police tactic, such as physical abuse or threats or deprivations of food or sleep or medical treatment. Or there was one case, State versus Steele, where an officer kidnapped and then falsely charged the defendant's relative in order to coerce the defendant into confessing. That's obviously inherently coercive. Threatening to jail a defendant's parent, and also the defendant's children, and threatening to take kids away if the defendant doesn't talk. That was also State versus Steele. Or being held in isolation for hour upon hour without food or drink, and where the only escape is a confession. Those have been held to be inherently coercive. Tactics that have been held not to be inherently coercive are things like badgering the defendant. That's the Wiles case and State versus Cooey from this county. Also reminding the defendant of his responsibilities or her responsibilities to care for their family. That's been held not to be an inherently coercive tactic. promises to consider the defendant's cooperation in a favorable manner, also not held to be inherently coercive. Lying to the defendant in and of itself is not necessarily inherently coercive. And even having a group of officers show up at a defendant's door, in a large group, showing up en masse to talk with a defendant who doesn't even speak English very well, that's also been held in Zaragoza out of the 2nd District not to be inherently coercive. And if the court finds that it's not inherently coercive, the analysis has to stop and the statement cannot be suppressed. Only if the court finds, and the state's already made explicitly finds, that the tactic is inherently coercive, only then under the precedents may it move forward to determine whether under the totality of the circumstances the statement was involuntary. And under the cases that have looked at the totality of the circumstances, again, lying by police officers can be considered by the court, but lies by police officers aren't necessarily dispositive of the issue. So are suggestions of leniency by police officers. Those are not necessarily inherently, under the totality of the circumstances test, going to render a person's statement involuntary. And there are several cases that are cited in the briefs to back that up.
Also, what, and I know you've addressed this somewhat, but not to this degree, I don't believe. What if the officer had literally said to the person specifically, if you tell me that you did these things, I'll make sure no charges are filed against you?
That would be the different story, and that's not what happened here, obviously. If there was a specific promise that we're not going to prosecute you, then that lie would indeed be held to be, under the totality of the circumstances test, that would be held to be significant enough to overbear the person's will and induce them to involuntarily confess.
But isn't that similar to what happened here when the officer tells them, well, you're both consenting adults, if you just tell me what happened and it's consistent with what she said, then I can just close the case?
Actually, no, because she didn't make that specific promise of you're not going to be prosecuted, no charges are going to be brought. The closest she came was to say, I don't care what you do. And in similar cases, that's been held not to be either inherently coercive or to overbear a person's will under the totality of the circumstances test. So her statements in this were vague, and vague promises have not been held to rise to that, or fall to that level, I should say.
What about her stating that he needed to tell her about that stuff because if he doesn't, she'll, quote, have to make it a rape case?
Well, I think the context of that was that she would have to make a rape case, send everything to the state laboratory, and the investigation would continue on and on and on.
So the threat of him being subjected to a rape charge, which is what she's saying here, if he doesn't tell her the stuff that she's already said isn't wrong.
Well, she didn't specifically say we're not going to prosecute you. She said a rape case. And in the context of everything that she was saying during the course of the less than an hour-long interview with him, she didn't say we're not going to charge you. She kept saying, if you don't corroborate what the victim said, then this investigation is going to continue. We're going to have to send for instance, all of her bedding out to the state lab for DNA tests. You know, this is going to continue, and the investigation is going to go on for months. But if you tell me what happened, if you corroborate the victim's story, this process is going to end. And actually, that's a true statement, because with a confession from the defendant, the process would end and the investigation would end. But if he did not confess, there would have to be further investigation. So it wasn't like she was lying to him. That investigation was going to go on in the absence of confession.
But except that she's already said she's over 18, you're adults, whatever you do is consensual, so I think that's where the...
Yes, but there are other
Disconnected.
cases There are some very similar cases to that we cited in the briefs, and that say that that's not specific enough to overbear a person's will. She was just vague enough to not fall into that trap of saying, we're not going to prosecute you, you're not going to actually be charged with rape. And so under those tests, it's the state's argument that the trial court committed an error of law that, again, this court reviews de novo and not under an abuse of discretion standard. And so, again, we have no promise, no direct specific promise of no prosecution. We also have an interview of less than an hour. At all times, under the totality of the circumstances test, at all times, this defendant was free to leave. He was told that he was free to leave at least twice. And he was not mistreated in any way. He arrived under his own free will. He was not handcuffed, not charged, like I said, he was free to leave, and in fact, he did leave with his parents. So it's the state's argument that under either prong of the Colorado v. Connolly test, the trial court erred in suppressing his statement. And on those grounds, because I see that I'm coming up against my rebuttal time, unless there's nothing more I can say during rebuttal, the state would again ask you to reverse and remand this. Thank you.
Thank you.
I've got stuff everywhere. Morning. Attorney Lowry, 0031017 appellate Craig Wilson. Let me just, I guess, and I'm confused now with the state's position, quite frankly. This isn't a case about minimization or deception. This is a case about flat-out lie. And if you read the trial court's opinion, which I'm sure you have, and as this court knows, and I don't need to tell you, there's great deference placed upon the court's decision because they have an opportunity to see the demeanor of the witnesses and review everything at the time it's happening. But Judge Breaux made a specific finding on the last page of her order. She said that Sergeant Moore made a number of false statements and engaged in a pattern of deception which interfered with the victims, with the ability to consent, including, and she even goes to say that some of the things that the officer did were just pure and simply wrong. Okay? This isn't a case about misrepresentation or, as the police officer talks about, so-called deceptive police interrogation tactics. If you read the transcript, she alludes to deception, that she's allowed to use deception. I questioned her. There's a big difference between deception and lies. And once, and also this issue of that the police are allowed to lie in some respects, but the difference here is that the lies were misrepresentations about a lot of things, from a totality standpoint, a circumstance standpoint. But most importantly, if you take a look at Judge Breaux and where she was coming from and where I was coming from, is that this officer flat out misrepresented the issues of the law. And that's, if you take a look, at Colorado, you take a look at, that's the line that must be drawn between permissible police conduct and conduct deemed to induce or tend to induce an involuntary statement. It pins, a lot of it is on the nature of the benefit to be derived by the defendant. There is no doubt, if you read this thing and you review the video, that this police officer on multiple occasions told my client that he had done nothing wrong. She told him that he wasn't in trouble, and she told him that if he merely and simply told her anything that was consistent with what she relayed to him, that the alleged victim was saying, that at that point in time, that he was free to go, there would be no charges, but it didn't matter because he didn't break the law. I mean, she comes out and tells him that. you have done nothing wrong. You know, you're consenting adults, you do what you want. If you tell me what I want to hear, which is what she's saying, tell me what I want to hear, we're done, I don't have to bring your grandparents involved in here, I don't have to do all this investigation and DNA collection and analysis, I don't have to keep this case open for months and months and months. At one point she even says that she'll keep the case open for as long as she lives. Okay, those are inducements that I guess in some world may be okay, but where she crossed the line is where she misrepresented and lied about these people and the law of the state of Ohio. It was beyond fraud. And what I'm confused about now is the state comes in and says, listen, you don't have to take a look at the totality of the circumstances unless there's an inherently coercive technique that triggers that analysis. And in this case, there was no inherently coercive technique. And then the state goes on to cite things such as, you know, being deprived of food, being kept in the dark, being hung upside down, you know, all these things that we might see on TV or we used to see on TV. So unless you have one of those, we don't go any further. That is so ridiculous that I just can't, that it's hard for me to get my hands around that, because then the state cites the Steele case in their brief, which involves, and the state even says, at page 3 of their reply brief, it is inherently coercive for police to use a materially false or fraudulent writing with malice, bad faith, wantonness, or recklessness as part of legitimate interrogation of a suspect. Okay? If that's an inherently coercive technique, by the state's own acknowledgement, because you talked about her specifically about Steele's, you're trying to tell me, the state's trying to tell me that it's an inherently coercive technique to, in addition to those things where people are chained and beaten and not fed and kept in the dark, but you can't use a materially false or fraudulent writing. That's fraud. So in other words, they're saying fraud is an inherently coercive technique. There is no doubt that what this police officer did was fraudulent. It was beyond that. And in fact, Judge Breaux agrees that it was beyond fraud, it was misrepresentation, and they were just blatant laws about the law in the state of Ohio.
Counsel, although I personally may not be happy with a lot of things that I have come across, the techniques that police officers have used, such as, you know, well, if you don't tell me what happened, I'm going to have to charge your mother, I'm going to have to charge your kids, you're going to lose your kids, you know, all these type of things. You know, there is a line of cases, and I know you cited some of them, but there's also a line of cases, both sides have, I should say, that talks about the fact that, you know, that a police officer is not your attorney, and a police officer can't represent what the prosecutor will do, cannot be held to tell you what the prosecutor will do. There's those lines of cases too. And whether I'm particularly comfortable or not in regard to the law, an argument could be made here that she did not tell him he would not be prosecuted, that she would only close the case.
I guess I have two comments to that. The law is clear that what a defendant perceives is based upon, you know, everything, and it's not just one statement. It's based upon the so-called totality of the circumstances, everything that was said. And I would suggest that I would agree with you if that's all there was, that just said, listen, if you tell me what happened, I'll close the case. That's not what she said in this case. In terms of your other comment about, you know, I'll charge your grandparents, it is an inherently coercive technique to say, I'm going to charge your grandparents, unless the grandparents have a nexus to the crime and they may be properly chargeable. And that's the distinction, I think, is that the statement of a police officer saying, I'm going to charge your grandparents in this case, there was no basis or means or nexus between the grandparents for them to be charged. That would be. There's an abundance of case law that says that would be an inherently coercive technique. That's akin to what happened here, is that the police officer gets my guy in there. I didn't do, you know, you've read it, but on more than one occasion, you know, she might not have come out and said, okay, listen, if you tell me what I want to hear, not only will there not be a prosecution, but you're gonna go home today and you will never hear from me and you will never hear from anyone else. But that's just not the way it works. What she did, in essence, through her actions and through her conversations and through the things in her representations, she in essence said that. And that's, when you go back to the trial court, if you read that order Judge wrote, who had the opportunity to see the demeanor of this officer, was flabbergasted. I mean, you read that, that's an order that is penned almost out of frustration, saying, and normally, I don't come here every day and see what you're doing, but I would venture to guess this is somewhat of a rare decision for this court. I would venture to guess that you see a million cases where people are saying, oh gee, the court erred in not suppressing my statement because it was coercive, and it's the other side, I might be sitting over there. I would venture to guess that you see these very rarely. I may be wrong, but I think I might be correct. And to just have one come through you and through me, I've been practicing a long time. And I don't know that I've ever seen but one or two cases where I've actually, personally, or in speaking to other lawyers, that they've actually gotten a statement suppressed. And that may go to your argument that, I don't necessarily like the things the police do or the techniques they use. Judge Grove's been on the bench for a while. Terrible at times. But I would be very, 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 very surprised if she hasn't had this case a plethora of times. Many, 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 many times. And I would venture to guess that 99% of the time, she overrules motions like this for the reasons that you've expressed, Judge Carr. But she didn't in this one.
Counsel, let me go to another point that was one of your arguments, that the police officer, Sergeant Moore, had said, well, you're both adults, consenting adults, you can make your own decisions. But at one point she also said, and I think you even pointed this out in your brief, well, do you think she's able to make her own decisions? She asked the defendant if she thought that this young lady was able to make her own decisions. And he said, yes, I do. I think she's able to make her own decisions. And she said, then, well, what do you have to worry about? How about that? I mean, that kind of cuts against you a little bit, doesn't it? Because she was actually consulting him in regard to that and not just telling him she's able to make her own decisions.
Well, I don't think that if you read the transcript in context, this is after she's already told him, as I recall, that she's a consenting adult. She's able to make her own decisions. So, I mean, if the cart was put before the horse, perhaps it might, cut a different way. But this is after she's already represented that she's a consenting adult. She can make her own decisions. You can make your own decisions, can't you? And so that conversation takes place at a point in time where it's my recollection of the conversation that she's already expressed that there's no issue, that she's a consenting adult, that she's old enough, and that there's no issue with her ability to make that determination.
Do you disagree then that there's a two-step process that you first have to find that the statement or the technique was inherently coercive, and then look at the totality of the circumstances?
Jen, I can't, I have, let me put it this way. That appears to be the case law in the state of Ohio. It appears to be the case law in the state of Ohio. But if you read, for example, Fouts, which is cited in my brief, and it's a state v. Fouts. I quote this as 216 WL 107-1457, Court of Appeals out of Washington County. They specifically say in rendering their decision, and this is good laws for 2016. One of the things they say that it's okay for the police to minimize the seriousness of his actions, but they on page or paragraph 2 of their decision make the specific finding or statement, there was no evidence of promises of leniency, misstatements of law, or types of deception or coercion by the police that would overcome his will and force him to make an involuntary confession. I think that, in response to your question, that is the law in the state of Ohio, but I think it's somewhat amorphic, and that the state seems to postulate this perception that you need some egregious first step in order to beat the defendant up, so to speak, bloody him up a little bit, before you move on to other, coercive techniques in order to accomplish that. I don't believe that that's the law. I believe that the misstatements and promises by the police, particularly of the law, misrepresentations of the law, which there should be some sanctitude about that. Misrepresentations of the law are so egregious that I think that forms the basis for the first prong. And I think that case law supports that. The Steele case supports that. I believe the Fouts case supports that. And if not, think about a world where the police could get somebody in an interrogation, and the first thing they would do is walk in and say, listen, you're in no trouble, you didn't commit a crime, if you just answer my questions and tell me what I want to hear, you're free to go and nothing will ever happen. Under the state's perception, that's not an inherently coercive technique. Where are we going in this country if that doesn't rise to the level of a violation of a plurality of constitutional questions and rights that people have? So I guess what I'm saying is I don't think it's as structured as find one and then you can find two. I think it's if you find that the totality of everything satisfies a court such that what you did was clearly against the law and wrong, I believe that satisfies both prongs of any test, and the Fouts test.
And counsel, I'm sorry to interrupt.
Okay.
Thank you.
Thank you.
As you can see, you have 3 minutes and 56 seconds.
Thank you, Honor. I would like to address your questions about the two-prong test regarding Colorado versus Connolly. Counsel says that's the law of the state of Ohio, and he appears to disagree with it. I would refer the court to the Ohio Supreme Court's decision from 2014 in State versus OC, specifically paragraph 93, where the court discusses alleged coercion. And even though the court says that in deciding whether a defendant's confession is involuntarily induced, the court has to consider the totality of the circumstances, it then says, and I quote, nevertheless, the use of an inherently coercive tactic by police is a prerequisite to a finding of involuntariness. The court goes on to say that consequently, unless the detectives used a coercive tactic, that court need not assess the totality of the circumstances. That's following Colorado v. Connolly. That's the law of the state of Ohio. That unless the court finds that there is an inherently coercive tactic that's been employed, it may not move on to the totality test.
But to go back to Judge Carr's initial questioning about whether or not the court made that finding, I understand the state's argument is it needs to be done explicitly. In the court's order, when talking about the Fouts case, the court says Sergeant Moore, now there's a word here, indirectly told the defendant if he confirmed the victim's statements, there would be no charges against him. That sounds to me like a finding of the court that there was a coercive tactic. If you look at the law about, I promise you, there'll be no charges against you if you just tell me what I would like to hear. Does the word indirectly make a difference in this instance? Is it like the Miranda cases where you actually have to ask for the attorney? There's no wiggle room about moving forward, or is indirectly good enough?
The state's position, obviously, that indirectly is not good enough. And I would refer the court to State versus Fouts, where at paragraph 36, the court does say that while deception is a factor that bears on the voluntariness of the statement, this factor standing alone is not dispositive, and that the quote, vague and indefinite statements do not render a confession voluntary. So it can't be, vague and involuntary, the implicit, implied can't rise to the level of making a confession involuntary. So that's why the state disagrees respectfully with the trial court in this case.
And counsel, if we say that the trial court had to do it explicitly and say, first and foremost, the court finds the techniques used by this particular officer to be coercive, inherently coercive, and then go through the totality of the circumstances. If we find that, wouldn't the case just go back for the trial court to do it over again and just basically say that?
That's a distinct possibility, Your Honor. Yes. Otherwise, I see that I'm rapidly running out of time, and again, the state thanks you and relies for the rest of the arguments on their briefs and urges you to reverse and remand. Thank you very
Thank
much.
The court will take the matter under advisement, and we will send written opinions to you both. And I ask you to look on the website, and you'll see that we release our opinions there, and you can look at them before you get them in the mail. All right, thank you so much.
Thank you, Your Honor. Have a good weekend.